Okay. Good to go.
All right. All right. Good morning, everyone. Can everybody hear okay? Okay. Good morning, everyone. I'm Cinnamon Carlarn, the very proud 19th president and dean of Albany Law School. And I have the pleasure of welcoming you to the conference today. So first of all, thank you all for being here to attend this symposium. It really is wonderful to see so many members of our community and such a very diverse group of experts that are here today, both in person and online. So welcome wherever you are. I also want to specifically acknowledge and thank our Government Law Center and the Government Law Review for organizing this very timely and very important symposium. Our Government Law Center, as I'm guessing many of you in the room know, plays a very unique and vital role, and I would argue probably more vital than ever right now, in bridging the gap between government and academia, providing nonpartisan legal research and analysis on really pressing legal and political issues, some of the most pressing and legal political issues of our time, as evidenced by today's symposium. The work of the GLC really does help inform public discourse and shape more effective legal and political responses. And this symposium is really a perfect example of their commitment, our commitment to that mission. Equally important, the Government Law Center is a very student-centered, and it provides our students with a range of pretty incredible opportunities, I have to say. We're always marveling over all the experiences our students have being in the Capitol and with the opportunities the Government Law Center provides for our fellows, for our interns, and more. The work of the Government Law Center is also complemented by our really exceptional student-run Government Law Review, which publishes research by some of the leading scholars in the field. The members of the Government Law Review really are a dedicated and exceptional group of students. I'm really proud to say that drawing on our strengths is evidenced by the work of both the Government Law Center and the Government Law Review. Albany Law School was recently ranked as the #1 law school in the nation for teaching government law. In addition, just last week, another success, and in fact, an Albany Law Government Law double success, when Dean Ray Brescia's Albany Government Law Review article on mortgage discrimination was cited by the Second Circuit. So congratulations to Dean Brescia, but also congratulations to the Law Review. A really fantastic group of community, both across the Government Law Center and the Government Law Review, both. Now, turning to cannabis. Everyone who in this room, I'm guessing, is pretty aware that the legal and policy landscape surrounding cannabis is pretty fascinating, it's complex, and it's evolving rapidly. And the legal and political issues in the cannabis space are really plentiful and require creative thinking and lawyering, which I think you're going to bear witness to today. From issues of regulation and licensing to social equity and criminal justice reform to energy consumption, and of course, right in my wheelhouse, environmental and carbon footprint, to banking, and beyond, the implications of cannabis legalization are far-reaching and really demand careful consideration. But even more than that, and again, this is why it's so unique that we're having this today, it really demands really smart and resourceful and creative lawyers and lawyering. So this symposium, with its very impressive lineup of speakers and panelists, really does offer a pretty terrific and unique forum for exploring the multifaceted issues and really encouraging creative thinking and kind of cross-issue dialogue. Now, I want to just again commend the organizers, especially those at the Government Law Center and the Government Law Review, including the fantastic leader this year, Caroline Drinker, the editor-in-chief of the Law Review, and also Rachel Brown, who's the managing editor for business and production of the Government Law Review, and has put so much time and effort into organizing this event. Really nicely done. Congratulations. There's no doubt that the conversations that we're going to have here today will continue to help shape a responsible and equitable cannabis industry, and I'm excited that we're able to host these conversations here. And I'm looking forward to moderating the second panel later this afternoon. But for now, I have the pleasure of turning the floor over to our really fantastic director of the Government Law Center, Pat Wilds. So just let me turn it over to Pat while also offering a final thanks to everyone who has helped plan this event, but also everyone who is here today to engage in conversation. So thank you and welcome.
Good morning. How's everyone doing today? Great. 11 a.m. is a pretty good start time when I say good morning. I'm used to saying 8:30 or 9, so hopefully everyone's a little bit more lively than 8 or 9. And thank you, Dean Carlarn, for the introduction and for all of your support of all of our government law-related efforts here at the law school. As you mentioned, there's no time like the present when it comes to analyzing pressing issues in front of government generally. Here at the Government Law Center, our major focus is on state and local government, but we're kind of left at this point in time having to look at how decisions being made on the national level impact things here in New York as well. So we're doing a lot of that. As the dean mentioned, I'm Pat Wilds. I graduated here in 2016, but more relevant to this discussion, I'm the director of the Government Law Center here at the law school. And we analyze and foster important discussions around pressing issues in front of state and local government. And we're also really focused on training the next generation of public sector lawyers and leaders. And a big part of my emphasis is certainly we have a lot of attorneys that are going to want to end up in the litigation space. That's great. But I'm really focused on the macro side as well and helping train lawyers who want to be on the public policy side, because I think we need more and more of that. And again, no time like the present. A few details about the specifics of our role in this event. This is part of our, since 1996, the Edwin L. Crawford Memorial Lecture on Municipal Law. So like I said, we focus on state and local government. This is a really great opportunity every year to really hone in, as far as we're concerned, on the local government side. This lecture series has been around, like I said, for over 20 years now, 30 years, I guess. Yeah, wow, time flies. And it's named after Edwin L. Crawford, the former executive director of NYSAC, New York State Association of Counties, who was a good friend to the law school and really spent his professional life educating and bringing to light a lot of issues as they impact local government across New York State and municipal government across New York State. So that's the goal of this lecture series, and we're really glad to bring it to you today. Before we kick the program off, and I'll pass it to my colleague Chell in a minute, we also want to introduce a pre-recorded video from another friend of the law school, State Senator Jeremy Cooney, who's a 2010 graduate of the law school, and also pertinent to this discussion is the chair of the subcommittee in the state Senate focuses on cannabis. So I'll hand it over to Jeremy, who represents the city of Rochester, the town of Brighton, and western suburbs of Monroe County here in New York State. So thank you again all for coming. Thank you for everyone that's helped organize it. Chell, everyone on our team that's helped organize it. Thanks for coming, and we look forward to a great program.
One moment.
Hi, everyone. I'm Senator Jeremy Cooney, a very proud Albany Law School alum and the chair of the New York State Senate Transportation Committee, and for today, the chair of the Subcommittee on Cannabis. I want to thank Patrick Wilds and the entire team at the Government Law Center for putting this event together. I know today's symposium is going to give an in-depth analysis of New York's cannabis market, both where things have gone right and where there's been some bumps in the road. I was proud to vote for the Marijuana Regulation and Taxation Act, or MRTA, in 2021, officially legalizing cannabis in New York. What set New York apart was our focus on social equity and our belief that the only way to establish a legal cannabis market was to establish one that benefited those impacted by the failed war on drugs. That belief began a series of lawsuits early on that tried to stop the progress we were making here in New York, but things are finally beginning to move along for our small business owners. This year, OCM, the Office of Cannabis Management, officially reported $1 billion in legal cannabis sales, an important benchmark for us to take stock of how far we've come, but also a reminder of all the work that lies ahead. We know that there's more work to do. Last year, I worked to combat the rise of illicit and potentially dangerous retail stores, made changes to the potency taxes to allow businesses to stay afloat, and worked to bolster our medical cannabis industry. Of course, the work doesn't stop there. I'm excited to hear about the conversations you're going to have today and your analysis of where the industry is headed here in New York. We still need to open up more retail dispensaries. We have to deal with new products such as the hemp-derived beverages, and to backstop the cultivators and the processors who will prepare for our upcoming supply needs. Here in the New York State Legislature, we will continue to build upon an equitable, thriving market for years to come. Thank you for the opportunity to say a few words today, and best wishes for a successful symposium.
Just one moment while I get the next piece squared away. Okay, thank you all very much for your patience and for joining us today. I'm Chell Miller, Program Director at the Government Law Center. I'm happy to introduce our first two speakers of the day, who'll be talking about municipal powers under New York State's cannabis laws and regulations. I'm happy to introduce Corey Auerbach, a class of 2007 at Albany Law School, of Barclay, Damon, and Jason Klimek of Manatt, Phelps, and Phillips. Thank you.
Have a green light, so that means I'm a go. So good morning, everybody. Thank you so much for being here. I'm thrilled to be here with my colleague Jason Klimek. Jason and I worked together for many years as he led Barclay Damon's cannabis practice area. So it's wonderful to be back here with Jason to speak with you today. And I did prepare some remarks, which is a little unusual for me as a land use and zoning lawyer. I'm used to standing up before municipal boards to present applications on behalf of my clients, and it's rare that I actually have prepared remarks, but today I do. And before I get into those prepared remarks, it's been such a fun trip down memory lane for me. 21 years ago, I sat in this very room on my first day at Albany Law School and sat next to a woman who would eventually become my wife. And I've had great mentors at Albany Law School. My sister is an alumnus of Albany Law School. But as I turned to my wife this morning and said to her, you know, in your wildest dreams, did you ever think I would be returning to Albany Law School as a lecturer? She looked me in the eye and said, Corey, you're not in my wildest dreams. So, but here we are. And like I said, I've had some wonderful mentors here, most notably Professor Sandra Stevenson, my local government professor, I believe founded the Government Law Center, the first female professor at Albany Law School. And of course, the preeminent land use scholar in New York, Dean Patricia Salkin, who was my mentor at Albany Law School as I interned at the Government Law Center. It is so comforting to look up and see my friend Bob Batson here, who I worked alongside at the Government Law Center. And I'm very grateful to Dean Salkin for her mentorship throughout the years. So I appreciate the opportunity to be here to discuss an issue that sits at the heart of municipal land use authority under the cannabis law. The intersection of zoning, preemption, and time, place, and manner regulations is really at the heart of what we're going to discuss today. Jason and I will be walking through different aspects of how municipalities can and cannot regulate cannabis businesses under this evolving legal framework. But I'm going to start by focusing on the key preemption issues, where local authority begins and ends, and when it comes to zoning and land use restrictions, what place municipal regulators have. After that, Jason will take us through a much deeper dive into the regulatory framework and practical considerations that municipalities must navigate. He'll take us through the cannabis law, he'll take us through the implementing regulations, and a much deeper dive into some of the topics that I'm going to touch on. As municipalities confront the reality of legal cannabis businesses operating within their borders, they must navigate two legal constraints under the cannabis law. First, they are preventing from adopting laws, quote, pertaining to the operation or licensure of cannabis businesses. And second, while they may impose certain time, place, and manner restrictions, those restrictions cannot be, quote, unreasonably impracticable. What is unreasonably impracticable? I think we're all asking that question. No one is certain, but we're going to provide some insight as to what we think may be unreasonably impracticable. The question I want to focus on today is where zoning fits into this framework. Because while zoning in and of itself may not pertain to the operation or licensure of cannabis businesses, there are zoning provisions that could cross into impermissible time, place, and manner restrictions, particularly if they create unreasonable, impracticable barriers of entry. This is where municipalities are likely to see challenges arise. New York's cannabis law states that municipalities are preempted from adopting any law, rule, ordinance, regulation, or prohibition pertaining to the operation or licensure of what I would generally refer to as cannabis businesses. At the same time, the law allows municipalities to impose time, place, and manner regulations as long as those regulations do not make the operation unreasonably impracticable as determined by the board. And that's the Cannabis Control Board. The regulations further define time, place, and manner in section 119.2 of the regulations, which authorizes municipalities to impose restrictions in 10 specific categories. And as Jason takes us through those categories, you'll see that the language of the regulations appear to create what we believe is an exhaustive list. This creates a two-part legal analysis for any local zoning restriction. First, does the zoning law, quote, pertain to the operation and licensure and is therefore preempted outright? Second, even if it is not preempted, does the zoning law function as a, quote, unreasonably impracticable time, place, and manner restriction and is therefore invalid? Now, we know from past land use preemption cases, particularly Frew Run under the Mineland Reclamation Law and the duo of fracking cases under the Oil and Gas Solution Mining Law, that courts distinguish between zoning as a land use tool and zoning as an industry regulation. This precedent suggests that zoning is not, in and of itself, preempted under the cannabis law. However, just because zoning does not, quote, pertain to operation or licensure does not mean it automatically qualifies as a permissible time, place, and manner restriction. Some zoning restrictions may still be preempted if they functionally eliminate dispensary operations or impose unreasonable burdens that make operation impracticable. And I focus on dispensaries, although the same logic would apply to on-site consumption establishments. Examples of zoning that could cross into impermissible time, place, and manner restrictions include expanding the 500-foot public youth facility buffer, functionally prohibiting dispensaries in commercial areas, zoning dispensaries exclusively in industrial districts with no practical retail locations, or requiring a special zoning permit process with vague discretionary approval, creating an uncertain path to compliance. These types of zoning laws may not explicitly regulate operation or licensure, but they could still be challenged as time, place, and manner restrictions if they make it unreasonably difficult for dispensaries to operate. So what legal standards are the courts likely to apply when evaluating zoning restrictions for cannabis businesses? If a municipality restricts cannabis businesses through zoning, courts will ask whether the law serves a legitimate land use function or whether it effectively prevents businesses from operating in a way that conflicts with state law. A zoning rule that eliminates all viable locations imposes significantly greater burdens than on comparable businesses or expands state-imposed restrictions beyond what is allowed in the regulations, specifically section 119.2, may still be preempted. Courts have long held that municipalities cannot use zoning as a tool to indirectly prohibit a lawful land use. In land use cases involving adult businesses, liquor stores, and even fracking bans, courts have looked at whether regulations preserve legitimate zoning objectives or whether they are designed to undermine state policy. The state's time, place, and manner framework in section 119.2 may serve as a ceiling, not just a floor. If a municipality expands time, place, and manner restrictions beyond what the state has authorized, such as creating new proximity buffers for facilities not included in the law, it risks being preempted. Courts will also examine whether cannabis businesses are being treated differently than comparable businesses. If a municipality allows liquor stores or pharmacies in a commercial district but prohibits cannabis dispensaries in the same area, this could be viewed as an arbitrary distinction rather than a legitimate zoning regulation. If a town requires cannabis businesses to undergo a special review process while other similarly situated retailers do not, that could also raise a preemption challenge. So as a final thought, even though zoning is not necessarily outright preempted, it must be carefully structured to avoid crossing into impermissible time, place, and manner restrictions. Courts will likely look at whether the zoning rule creates a disguised ban, imposes heavier burdens than on similar businesses, or goes beyond the time, place, and manner limits set by the state. Municipalities can regulate where cannabis businesses go, but not how they operate. If zoning laws function as disguised operational regulations, they will not survive legal scrutiny. Like the preemption cases before it, only time will tell where the courts shake out. Needless to say, Jason and I, along with many others, some of whom I'm sure are in this room, will be monitoring where the courts land and what, if any, legislative changes may result from those decisions. So I wanted to start by discussing the preemption issue and its intersection with zoning, because many municipalities with whom I work are struggling with that very question. The body of case law is nascent. I like to think that Jason's firm and my firm may have an opportunity to create some laws in those areas. And some of the first proceedings that we're seeing relate to the proximity requirements and municipal authority to either expand or create new proximity restrictions, not only for cannabis retail dispensaries and on-site consumption establishments, but also in between those businesses, and also limitations on the number of businesses that may be located in specific areas. So the question of municipal home rule law, of the breadth of municipal authority, is one that we believe will continue to be considered and one that we'll be closely monitoring. I'd be happy to take any questions. Other than that, I'm going to turn it over to Jason in a moment to take you through that deeper dive on the regulatory framework and the considerations that municipalities are navigating. But to end where I finished, it's with great gratitude to be here at Albany Law School. My thanks to Dean Carlarn, and also to Pat Wild and the Government Law Center. And thank you all so much for being here.
Thank you, Corey, and thank you, everyone, for having me here. So just to give a quick little background on myself, I am a tax and corporate attorney turned regulatory. So I always turned to Corey when it came to municipal stuff. The first time home rule law came up, I was like, what the hell's home rule law? And so Corey has been kind of, the guiding light when it comes to all this stuff, because just like tax is its own thing, municipal land use zoning is its own thing. And so Corey and I have worked together for probably, I don't know, 3-4 years on this stuff as it was starting to come up, as I was trying to learn more about it, because initially we saw, the opt-ins, and we'll get into all of the law on that, but the opt-in, or I should actually say opt-outs, you're defaulted to opt-in with one little caveat. And so as all this stuff was coming up and we were learning how municipalities were going to look at this, how zoning was going to work, as the regs started to be drafted, we were kind of learning all of this, and I was learning a little bit of municipal law on top of it. And now we're kind of in the thick of it. We see these municipalities that have not opted out, but put in what may be called unreasonably impracticable, or may just be preempted, local laws that are kind of prohibiting a lot of these businesses from opening. So they've remained opted in, yet they can't get these businesses open. And just to mention, so my partner at Manatt is Axel Burnaby. Axel, he was the former Governor Cuomo's assistant counsel to health. He kind of ran the medical program a little bit, and then he transitioned over to the Office of Cannabis Management and stood that up with Chris Alexander, the former executive director. And he was there till I think about September of 2023. And Axel and his team were the drafters of the regulations. And So they were really under the gun when they were getting these regulations out. The regulations were finalized, I think sometime around September of 23, I believe, something like that. We had the enabling statute signed into law March 31st, 2021. There was kind of a lag, and so they really needed to get these regulations out because they were going to open the licensing windows October of 23. So there were a lot of issues in the regulations, things that we didn't understand. You know, in the statute or in the regs, it said time, place, and manner, and we're like, that's a First Amendment issue. Why is that in municipal? And then, you know, we'll get into that. So I'm going to continue on, but I wanted to kind of give a little background there. Let's see. Oh, all right. Awesome. Okay. Hey. So section 131 of the cannabis law. This was the initial opt-out. So by December 31st, municipalities could opt out. If they didn't, they were permanently opted in, I guess. However, opted out municipalities do have the ability to opt back in permanently at any time in the future. And municipalities, for the purposes of the cannabis law, are villages, towns, and cities. Counties do not get a say. And it's also worth mentioning too, most of what we're going to talk about is for retail. That is really where the opt-in, opt-out conversation lies. It really does not affect the supply tier. So the supply tier are cultivators, processors, and distributors. Opting out localities only really opted out of retail sales. Interestingly enough, can still deliver there. So subdivision 2 is kind of where the regs, what the regs more clearly defined. So this is the preemption. They are preempted from adopting any law, rule, ordinance, regulation, or prohibition pertaining to the operation or licensure of registered organizations, which are the medical companies, adult use cannabis license or cannabinoid hemp licenses. However, towns, cities, and villages may pass local laws and regulations governing the time, place, and manner of operation of licensed adult use cannabis retail dispensaries and or on-site consumption, provided such law or regulation does not make the operation of such licensed retail dispensary or on-site consumption unreasonably impracticable as determined by the board. Just to note, there are no on-site consumption licenses available. On-site consumption is something that has not been authorized by the Office of Cannabis Management at this point. So we're really only talking about retail dispensaries, or there's one class of license called micro businesses. Those are fully vertically integrated, and they're, besides the medical companies, they're the only ones that are allowed to be fully vertically integrated. The micro businesses can have a retail component, and they would be subject to the same rules as retail dispensaries. In the regulations, section 119 is all of the municipal rulemaking and things like that. So 119.1A, no municipality may adopt a local law which would allow an adult use retail dispensary micro business, ROD, which is, that is a registered organization that has obtained its adult use licensure and has a dispensary. There's two types, ROD with a dispensary, ROND, no dispensary, or on-site consumption. So I bolded a couple things here because these are things that actually come up a lot. You can actually see these issues come up whenever the Cannabis Control Board issues licenses. They also, at the back of that resolution, they will put out the responses to negative municipal opinions. And a lot of times, municipalities will enact local laws that say, for example, a dispensary can't locate within 200 feet of the lot line of a house of worship. Not allowed. The regulations specifically provide for on the same road. And when you look at this, you got to kind of think of it too as like New York City centric a little bit. because it's so dense, they really made a point to make sure that it's on the same road so that if you're just around the block, it's not a straight radius. It has to be on the same road. So that's where that kind of idea came from. And it's to the entrance of the building. So those tend to be at issue in a lot of the cases that we tend to see in municipalities where they're saying lot line or they're expanding the distance. A very common one is instead of 500 feet from a school, it's 1,000 feet from the lot line. So yeah, the law provides 200, you can't be more than 200 feet from a house of worship, or it can't be less than 200 feet from a house of worship, can't be less than 500 feet from a school. And if the municipality enacts a local law determining that you can't be within 500 feet of a public youth facility, that's the relevant district there. You can go closer. So they could say 100, 200 feet from a public youth facility, but they can't say more than 500 feet. And a public youth facility is basically a government-run facility. So, park, beach, things like that. We're not talking about a private business that maybe caters to youth or something like that. That was actually in the first draft of the regulations, and it was called a community facility. They actually got rid of that and replaced it with public youth facility. Section 119.1B, this is where they are preempted specifically from adopting any of these types of local laws. And a lot of this was brought in from what OCM saw from other states and issues that they had seen. So imposing special fees for specific to cannabis businesses. And one of the things that you kind of have to keep in mind is that the intention of the regulations when it came to municipalities was really about not discriminating against cannabis businesses. In OCM's mind, other than the 10 things that we'll get into later, they're supposed to be treated like any other regulated business. If it's a smoke shop or a liquor store or something like that, those are close. If they're putting those types of businesses in a specific district, maybe that's okay if you lump cannabis into it. But if you just say no, every other type of business can go wherever they want, but only cannabis can go here, that's maybe where we start to have a problem. So the non-discriminatory aspect was kind of a thought process in the regulations. So they can't also impose a fee on adult use dispensaries. However, they kind of made the equivalent, or they said if you're doing this under the liquor law and you've done it before legalization, you can do that. OCM did pull a lot of the regulatory framework from the liquor law, and actually the statutory framework too is from the liquor law, creating the two-tier system. So 2 tiers, supply tier, retail tier, you can't cross the tiers except for what I mentioned, the micro businesses and the medical companies. So they can't impose a special tax on cultivation, processing, manufacturing, distribution, or any of the cannabis functions. And the last one here, this was actually enacted specifically to deal with a situation that was in Massachusetts. Massachusetts required these community host agreements for a cannabis company to obtain licensure. And what it became is these community host agreements were a way for the municipalities to get a lot of money from the businesses because they would only allow a certain number and so on and so forth. And so OCM had seen this happen because Massachusetts legalized in 2016, I believe, and began sales in 2018. I think that's correct. So they put the kibosh on that right out of the gate and said, you can't do that, because we saw what happened in Massachusetts. These are all continuing. Denying any right, privilege, permit, variance, or approval to adult use cannabis retail dispensary, micro business ROD, or on-site consumption associated with the premise where retail sales of adult use cannabis to cannabis consumers occurs and for which a license under this title has been in existence from a date prior to the date when there came. So this is basically grandfathering. So if you are an established dispensary and a house of worship decides to move in next door, you're not going to get kicked out. And then setting standards for ventilation and odor. They actually do allow this. This is one of the 10 things that they can regulate, and we will get into that. So here are those 10 things. And this is time, place, and manner, which just get it out of your mind that it has anything to do with the First Amendment. It does not. It even almost doesn't have anything to do with place. It's mostly time and manner. There's some very specific place functions, but mostly it's time and manner. So municipalities can regulate the hours of operation, but those hours of operation cannot drop below, they cannot force you to be open less than 70 hours a week. Was there a question? Feel free to ask questions, by the way. Happy to have a dialogue. So, yeah, so what is the practical effect of opting out? The practical effect is there's no dispensaries, or if there were on-site consumption, within that municipality. So that's the actual effect. They just don't exist in that municipality. You can, every other function is legal. So you can consume in that municipality. You can have cannabis delivered to that municipality. All it does is affect actually locating a dispensary within that municipality or on-site consumption. That's honestly it. They could have opted out and that would have been it. Yeah. But there is a component that it's kind of outside this, but I'll mention it because actually my area is tax. So there is a 13% retail tax that is charged at the point of sale. It takes the place of sales tax, so it's not in addition to your regular sales tax. And of that 13%, 9% goes to the state, and the remaining 1% goes to the county, 3% goes to the specific municipalities, and it's based on a ratio. So if you have 2 municipalities in the county, one is doing twice as much as the other, then they get twice as much of that tax revenue as the other one. And so it was kind of an incentive to opt in. And I can tell you, like, where I am in Rochester, my town specifically, they put it in our town newsletter for 2024, of which there were only 2 dispensaries in the entire town. They generated about $400,000 off of that, and literally said in the town newsletter, like, we don't have to raise taxes because of this cannabis tax. We didn't have to do anything. It's basically free money to us. And that's been kind of a big push for municipalities to opt in. I know, like, Suffolk County, Long Island, they host the top 1 and 2 dispensaries. And I cannot remember how much they made in 2024, but I think it was somewhere around 2 or 3 million. One of the dispensaries did about like 50 million in revenue, which is honestly crazy. Like, that is a way outlier. Most of these dispensaries, I think they're averaging 5 to 6 million. If you're doing probably 10 to 15, you're within the top 10 dispensaries.
Jason, can you go back a slide? Your question is a really good one about what happens if somebody opts out or opts in, right? Because in any jurisdiction that opted out of hosting a cannabis dispensary or an on-site consumption establishment, no one within that jurisdiction is eligible to receive a license. So if that jurisdiction has opted out, no one in that jurisdiction can be licensed. But that helps to understand a little bit the question of preemption, because municipalities had an option to remove themselves from this licensing regime. So for a jurisdiction that did not opt out, for them to, through their zoning regulation, effectively preempt a on-site consumption establishment or dispensary would potentially be preempted under these provisions of either the cannabis law, which was the section 131 that Jason spoke about, or the regulations, which is this section 119.2. And it's important to note the slide that's up on the introductory language to this section, because the last sentence is one of some consternation for practitioners, where it says, the following activities constitute the permissible time, place, and manner restrictions that may be imposed by a municipality, and then lists 10 specific items. And if you're utilizing strict rules of statutory construction, one might argue that the language of the regulation, which says the following activities constitute the permissible time, place, and manner restrictions, that is a limitation by creating an exhaustive list of time, place, and manner restrictions. So right now, presently, it is an open question whether these 10 items are the floor or the ceiling of the municipal regulatory authority in the space of time, place, and manner.
Thank you. Yeah, absolutely. And, you know, we've taken the position with our clients that that this is an exhaustive list. If it didn't mean to be exhaustive, they could have said including but not limited to. And they're pretty restrictive on what they can do and very specific. So yeah, 4 of them are literally just about the hours for dispensaries or on-site consumption. But then we get into the remaining 6 of them. So the visual or architectural integrity of a building if located within historical districts, parking, traffic control. Those 3 are the ones that kind of tangentially touch on place. And you'd really have to make a finding of that, I think, because it could trigger the unreasonably impracticable analysis. The odor pursuant to the public health law and Clean Indoor Air Act, that is really more for on-site consumption, noise, and the distance requirements between the dispensaries, micro businesses, or ROD, and a public youth facility. Also, just to note the last sentence there, the distance requirements for the public youth facility do not apply to Part 116 licenses. Those are card licenses, conditional adult use retail dispensary. Those were the first dispensary licenses issued. Those were issued to justice-involved individuals who had a cannabis conviction in New York and had a profitable business for 2 years. So they are not subject to the public youth facility. And those are the vast majority of dispensaries that are open right now. There's about 300, and if I had to ballpark it, cards are probably 250 at least of them. So here is the unreasonably impracticable language. Pursuant to subdivision 2 of section 131 of the cannabis law in this part, no local law, rules, or actions of the municipality shall be effective or enforceable if such action otherwise impedes on the duties and obligations of the board as set forth under the cannabis law, violates any provision of the cannabis law or this part, or discriminates against or frustrates the registrant, licensee, or permittee's ability to carry out the operations of such registration, license, or permit issued by the board. So that is the only place discrimination is actually in the regulations, but it's in the context of operations. And as Corey said, that creates maybe a little question as to how far operations extend and how does a municipality, can municipality enact certain zoning rules that don't affect the operation?
Can you go back one slide? I just wanted to highlight the 10th limitation here in the regulation section 119.2A. So again, by way of summary, if a local law relates to the, pertains to the operation or licensure, right, it is strictly preempted under the cannabis law. If it regulates operation or licensure, it is preempted. The next sentence in the law says, however, as it relates to time, place, and manner restrictions, municipalities can adopt laws or regulations relating to time, place, and manner, so long as they are not unreasonably impracticable. And then in the regulation, section 119.2 says, these are the time, place, and manner restrictions that are permissible. And I wanted to focus on the 10th one for a minute, because the 10th one talks about if a municipality adopts a local law, they can restrict via proximity protection the proximity to a public youth facility. So the legislature went out of its way to add a specific time, place, and manner restriction that says you can adopt a local law where you can change the proximity requirements. And so for me, that begs the question, if they said in this very limited area, you can change proximity protections as it relates to the location proximate to a public youth facility, does that mean that you cannot legislate in any other areas of proximity protection? The legislature clearly knew how to put a time, place, and manner restriction in place that discussed altering proximity protections. So the question of whether a municipality can create their own proximity protections, for example, if they could limit a dispensary from being within 500 feet of an arcade or of an ice cream shop, two things that I think would be very bad for business, by the way, for cannabis dispensaries to be prohibited from locating near those things. But it begs the question whether municipalities' jurisdiction to create new proximity protections other than those either in the cannabis law or set forth in the regulations would be permissible.
And also kind of the question of zoning, because one thing that I think, we all agree on, and speaking with the drafters of the regulations, is nobody ever intended to preempt a municipality's ability to say you can't locate a dispensary in the middle of a residential neighborhood. Nobody's arguing that. But when you start saying, well, but you can only be in these industrial districts, we don't care about smoke shops, we don't care about liquor licenses, but cannabis, you can only be in these. Is that okay? Yeah, question?
So how does that apply to proximity protection waiver? When the state gives a waiver and says, this dispensary can be, within 500 feet of another dispensary, and the municipality said, hey, we have a law where the proximity protection is 1,000 feet. Who supersedes who in that?
So I would take the position that the law, the cannabis law, preempts anything that says they can't be within. If the local law says you can't be within 1,000, that matches with the cannabis law. And just to be technical, in municipalities with population over 20,000, it's 1,000 feet between dispensaries. Under 20,000 is 2,000 feet. So we'll just focus on the 1,000 foot. If the law is consistent, if the local law is consistent with the cannabis law, all good. But if the Cannabis Control Board comes in and says, we're giving you a waiver under the public convenience and advantage standard, that, in my opinion, that would preempt the local law, because that is the state coming in and regulating on top of, or pursuant to their preemptive powers under the cannabis law. And the Cannabis Control Board has kind of said that, like they've not issued, or they've not spoke to that directly, but they have kind of said in their responses to negative municipal opinions where there's 1,000 feet between, like, the local law says 1,000 feet between schools and a dispensary. They say, no, this is inconsistent with the cannabis law. We granted them the license. Now, the problem is that's kind of where the Cannabis Control Board stops, is they say, we're granting them the license. And now you have the licensee that's kind of stuck in this limbo of, okay, I have the license, OCM's given me proximity protection here, but maybe I don't have a special use permit or something like that. But I would say that the local law would be preempted, and there are new proposed regulations that should probably be hitting the register, I'm gonna guess like next week or the week after, on the public convenience and advantage standards. And I didn't put much into this. I don't think I put anything in the slides about it, but it's an interesting issue. It really kind of goes outside of the municipal rules. It does. The new proposal, though, does give municipalities the ability to submit their opinion to the office when the office is doing the analysis as to whether or not they should grant the waiver for PCNA. And they're trying to build in with these new proposals more of a due process requirement. Before it was literally behind closed doors. They supposedly did the analysis of these factors and then the board just granted it. But now the proposal is to have an actual due process where the towns get input, the current licensees who the waiver would be, I guess, against, get to have input. But yeah, I think to answer your question, I believe that they would be preempted, and the waiver would override.
And I'm not aware of any case law that has been decided yet, which is what makes this such an interesting conversation and academic discussion. When a when a dispensary is licensed by the state, but a local municipal zoning regulation restricts them from operating, the answer may be in the next slide, Jason, in the language of the next slide, but to the best of my knowledge, we're all waiting to see what the answer to that question is.
Yep. And there may be some cases soon, particularly I find it in Riverhead, Long Island a lot, but Riverhead, there's a lot of issues out there that of local laws that we have felt that are preempted by state law, but we kind of see it all over the place. I think these cases are going to start coming up because initially when there was 200 licenses out there and nobody really had proximity protection and so on and so forth, there was like enough space. But now, even with 300, things are starting to get crowded because maybe the municipality has space, but it's off where nobody wants to be, and where everybody wants to be is within this little area. And so it becomes a real issue. And then municipalities, when they were zoning out some of these like cannabis, like call them like green zones, they didn't take into account that some of these places, like in plazas, they have like anchor tenants who have restrictions in the lease that say no cannabis dispensaries. So you can't even go into the plaza, even though it's in a green zone. And then it creates this entire problem of, okay, there's literally nowhere in this municipality that I can go, that I can rent a place or buy a place. And so that's where we see a lot of these preemption arguments starting to come up is, okay, these look like they should be preempted. Some people take the position that the unreasonably impracticable argument applies to everything, even outside of those 10 factors or 10 allowances for regulation. But we take the position that they're just straight up preempted. So you have to have some type of proceeding, whether it's Article 78 or a declaratory judgment action. Yeah.
Where there's a plaza with the lease, who has prohibited the cannabis dispensary?
So basically the lease would have a clause in it with, oh, sorry. So the question was, who would prohibit the cannabis dispensary coming into the plaza?
Take this where city that did not opt out. So technically it's a green zone. So we're creating prohibition in the plaza.
I think what Jason was suggesting is even where municipalities have identified areas where cannabis businesses can operate under their local municipal regulatory regime, one of the barriers is that there are private restrictions that some landlords have on its tenants that prohibit cannabis businesses from operating. And so there's an interplay where even when a municipality is restricting where they can locate, they can be even further restricted by private covenants. So in the case that Jason was discussing, he was giving an example of where private restrictions could further limit cannabis businesses that are already limited by municipal regulation.
And to just give an example of that, one of my clients was looking into a plaza that was okay by the municipality. When they started talking to the landlord, they learned that there was one of the healthcare groups was an anchor tenant, and there was literally a clause in the lease that the healthcare tenant had insisted on that no cannabis dispensaries could be allowed in the plaza. So it wasn't a municipal created restriction, but it was a practical restriction.
Like Price Shop, Corporation, Walgreens, that CVS, a lot of the pharmaceutical companies make sure that that caveat is in there. And for dispensary.
Yep, absolutely. So it just further restricts everything down. And so when you start piling on all these restrictions, these licensees start looking around saying, I can't locate within this town. And roughly about half of the municipalities in New York State opted out. So you're only dealing with half of the municipalities to begin with. And now some of them have almost, between their local laws and then, private covenants and things like that, they've almost effectively opted out. So kind of as we discussed, there are these 10 specific time, place, and manners. This is, the position that we're taking is they can regulate within these time, place, and manner restrictions, these 10 items, and they are subject to the unreasonably impracticable standard, which has not been tested. Outside of that, it is preempted. So here's some examples. Requiring a dispensary to close at 10 p.m., assuming that they're allowed to be open at least 70 hours a week. That's fine. Requiring a dispensary to adhere to visual or architectural integrity within historical districts, prohibiting a dispensary where parking or traffic would be an issue, or enacting a local law prohibiting a dispensary to be within 500 feet of a public use facility. Those clearly all okay. Some may be subject to unreasonably impracticable analyses. Here are some that are impermissible. Increasing the distance between dispensaries. So in a municipality with over 20,000 residents, you can't be within 1,000 feet of another dispensary. If they say, no, you can't be within 1,500 feet, 2,000 feet, whatever it is, preempted. Going beyond 500 feet for a school, preempted. Requiring lot line measurements as opposed to entrance measurements. So it's from the middle of the door that is the main entrance, or, when you're measuring from the dispensary. But if it's to a house of worship or a school, it can be any entrance that's not like a fire exit or anything like that. Prohibiting a dispensary from locating less than 500 feet from a school, that they cannot do that, and discriminating against cannabis businesses. That is what I would argue they can't do. Here are some gray areas. So can they be zoned, as I kind of talked about before, can they be zoned into specific districts? We don't really know that. And as I said, it kind of comes up, or it kind of presents interesting issues where everybody agrees you can't throw a dispensary in the middle of a residential neighborhood. So clearly there are some allowances, but how far do those allowances actually go? What about home rule law? How does that interplay with the preemption and the allowances of local laws? And then another example that Corey and I were talking about last night is, does a local law that requires a dispensary to be within a given distance prohibits a dispensary to be within a given distance for a restaurant, for example, does that pertain to the operation or licensure of a dispensary? Open questions.
And to be clear, this is not a settled area of law. So Jason is presenting these as what he believes would be prohibited. He's not saying that they are prohibited because a particular body of case law has determined that they are prohibited, because there hasn't been any case law yet on these issues. So these are things that I would say we are suggesting. Jason may say it a little more affirmatively than I do, but these are things that may be preempted because there has been nothing definitive yet on the topic.
Yeah, I definitely, not gonna lie, there's a little bit of a narrative. So what about the supply tier? Basically, there's not much to say about the supply tier. Cultivator, processor, distributors, they're just subject to regular zoning. There's no opt-out that affects them. And so if they want to, if it's an indoor cultivation facility and they say, well, you can be in light industrial or something like that, that's probably completely okay. There's nothing in the law that really prohibits that.
Because recall that the opt-out provision only related to dispensaries and on-site consumption. So every other area of cannabis regulation is subject to the cannabis law or the regulations.
Yeah.
Regarding on-site consumption, is this on? Can everybody hear me? Yes, it is. Not my question. I'll understand. When cities and villages get an opportunity to opt out of on-site consumption, let's say they've already said, okay, we said, okay, we never opted out of the retail dispensaries. Maybe they want to, maybe they're crowded down.
Yeah, they've lost the opportunity to do that. So the municipalities could opt out of dispensaries, they could opt out of on-site consumption, they could do both, but it had to have been done by the end of last year. Last year?
No, 2021,
20
December 31st, 2021.
2021.
They already did. Yeah, that was December 31st, 2021.
Maybe they want to opt out of the on-site consumption.
Again, they had the opportunity and a lot did. So like my town, they opted out of on-site consumption, but I'm just gonna say opted in. It's not technically correct, but opted into dispensaries. So that was the choice they made. And their idea was, okay, we're fine with dispensaries because they're kind of more like liquor stores. People go in, they buy, they leave, they go home. They were kind of iffy about on-site consumption. They didn't really know how it works because it's more like a bar. So people are going to hang out there, get ability impaired, and then driving. And they're like, let's just see how things go. We can always opt into that in the future. And so I think that was a lot of the rationale for municipalities. And I think roughly, as I said, 50% of municipalities opted out completely. But I want to say something like 70 or more percent opted out of on-site consumption. So they were okay with the kind of more liquor store model, but not so much the bar model.
That's a great question. There's about 1,600 units of local government, I believe. There's 932 towns. There's 60-something cities and 60-something counties, and then a number of more villages on top of that. But I believe the number is about 1,600 units of local government. That doesn't include school districts or fire districts or other municipal jurisdictions. I'm talking about cities, towns, and villages and counties.
All right, so another aspect of the law is the municipal notice. And all it does, so within 30 days and not more than 270 days prior to filing an application, you have to notify the municipality. All it does is literally, it's a 2-page form. It says, what's the LLC name, who's the primary contact, what's the address, and then you sign it. Like, that's pretty much it. And it just puts the municipality on notice, this is where you want to locate. And then the municipality has 30 days to express an opinion that becomes part of the record. In my experience, OCM doesn't really care. They literally are like, great, we don't care. Because they're looking at it from their licensing standard. They're not looking at it as whether this is good for the community or not. They're looking at it, does this meet the requirements under the law and under the regs for a dispensary to locate there? So I haven't really seen negative municipal opinions given that much weight. And here's one that, you know, they kind of expressed, they being CCB, expressed the negative municipal opinion, or expressed their response to the negative municipal opinion and said, the board appreciates the values, the concerns raised by the community board. In its review, the board determined that the proposed site is not in violation of any statutory or regulatory distances. And then they issue the license. So that's really what they're looking at is, are you too close to a house of worship? Are you too close to a school? Are you too close to another dispensary? No? Good to go. They want dispensaries open.
And this procedure was likely borrowed from the SLA, which has similar notification requirements related to proximity and notifying municipalities in advance of issuing licensing. There are unique features of it as well, particularly the response requirement that goes to the issuing municipality.
So this is where we find ourselves with several of our clients, some joint clients, that the CCB has issued the license. The OCM has given proximity, but the town says you can't start operations there. We're not giving you a certificate of occupancy, or we're not giving you the variance, or so on and so forth. And so they kind of get stuck, they being the licensee, gets stuck in this limbo of the state says I'm good, but the municipality doesn't. But maybe these municipal rules are preempted, or they're unreasonably impractical, or whatever it is. And really, we're sitting there in limbo. We're stuck. We, may have to go to court on them. There's really no ability right now to do an unreasonably impracticable opinion. It just doesn't appear that counsel at OCM has the bandwidth to do that right now.
To underscore Jason's point, there's a procedure that has been adopted into the regulations where if someone believes that a time, place, and manner restriction is unreasonably impracticable, you can get an opinion as to whether or not the board believes that it is. My understanding from Jason is that I don't know that any of those determinations have been given. Raises the question for me as a litigator, whether that would be required as part of the exhaustion of administrative remedies doctrine, although the language in the regulations appears to make it permissive, such that I think you would not be required to seek that determination before asking a court to review a determination on unreasonably impracticable. The question was whether or not, in practice, we are seeing circumstances where people have been issued licenses but are otherwise prohibited from operating due to local municipal regulations. And the answer, unfortunately, is yes. And that's why I somewhat tongue-in-cheek suggested in my prepared comments that we may have an opportunity to make some law surrounding some of these issues, or that law will be made surrounding some of these issues in the near future, because there are definitely a number of high-profile circumstances where proposed operators have found themselves in that position.
And just to add to that, these licensees are often paying rent, or at the very least property taxes if they own the building, upkeep and things like that, and they're not allowed to open and therefore not allowed to make revenue. So it's putting these people in very precarious positions where the towns or the municipalities are dragging their feet, but they have this license to operate from the state. And so now they're looking at, well, do we go to litigation? What do we do here? And so, yeah, we're seeing it a fair amount. And I think it's only going to we're going to see more of it until we start seeing case law actually being made and given guidelines as to what they can and can't do.
Pretty soon, OCM being enticed to get a property.
No.
Getting a lease or securing a property, because there was preference given to those folks who secured real estate.
Correct.
They were enticed. Secure your property, you're going to be on the fast. And now they've secured property, and the municipality will not issue the COs.
They're not, I would say, directly on point, but there was one case that's still ongoing, but resulted in an injunction back in December that was like this, and then through subsequent court clarifications, which it was actually kind of funny to continually watch these clarifications narrow down to the injunction to now it hits exactly 2 card licenses, I think, and the entire December Q retail, but that's a different thing. Get into it. But yeah, so one of the claims was basically, it kind of tangentially touched on that insofar as it really dealt with the notification municipality. So what they said was these card licenses, when you apply at least 30 days and not more than 270 before an application, you have to notify the municipality. These card licenses, that's not how it was. They were kind of broken up into two applications. There was the initial, which was kind of the qualifying applications. Are you justice involved? So on and so forth. That was enough to issue the license on. They went before the board, they were on a resolution, the license was issued. Then they had to do what was called the post-selection application. That's where they did the true party of interest analysis. That's where you would upload your lease and the notification municipality, so on and so forth. What this lawsuit said, and it's called Organic Blooms, is they said that violated the law. They sought a temporary restraining order, which I think was denied, and then they got a preliminary injunction. I want to say that's, yeah. So the injunction, the judge said, these cards, that have not been issued licenses at this point, it violated this, the section 76 of the law specifically. The interesting thing was that one part of the law was ignored for some of the plaintiffs, which is actually really interesting, like the 30-day requirement. So the judge agreed, well, you had to do it before, but the law requires at least 30 days, and the plaintiffs had not, and that apparently didn't matter. So, and then the rationale, which I don't really buy, is that OCM had come out and said, hey, we're not going to process your application for 30 days. And therefore, we don't consider the application filed for at least 30 days. So just have your notice to municipality submitted with the application. And then when we file it, it's been 30 days. So that's how I've seen it come up in lawsuits. So it's not exactly what you're talking about, but they did make the arguments. We've been paying for this. We were kicked out of, so we applied back in November of 23. In the interim, these cards slipped in and got proximity protection and knocked us out. And that's what they were kind of suing on, is we've expended these funds, we waited all this time, and these people kind of didn't comply with the law, but they knocked us out. And so that's where we kind of saw it come up, but not the direct issue. All right, let's see. I always think I'm not going to have enough material, and then I always have way too much. So very quickly, enforcement powers. This is a big topic in New York City primarily, but illicit dispensaries everywhere. What can municipalities do? So there was an amendment last year in the last budget that gave further powers to municipalities, really kind of focused on New York City. That's where they could padlock without a hearing. So they could come in, do a regulatory inspection, which if you don't know what a regulatory inspection is, it's people with clipboards. That is a regulatory inspection. They could come in, they see illicit product, and in New York City, they could padlock you right that day. Then you would have a prompt post-deprivation hearing, not depriving you of due process. Everywhere else, it had to go through an administrative hearing first, then they could padlock you. I'm going to skip ahead because this case touches directly on it. So this was a recent case where they were doing regulatory inspections with SWAT-style raids. There was probably 10 to 15 law enforcement, OCM coming in full tactical gear and literally raiding these shops. And the judge essentially found that those are not regulatory inspections. You need a warrant for that kind of thing. That's really more of a police action. And despite the fact that these shops were definitely selling illicit things, THCA flower, I can go off on a tangent for like hours on this.
Allegedly.
Yes, allegedly. But THCA flower is weed. Like, it's not a controversial statement. THCA is the precursor to like, okay, just really quickly, if you grow a cannabis plant in the ground, it has THCA in it. If you eat that cannabis or do whatever, it's not going to do anything to you. If you light it or heat it, it becomes Delta-9. That's the psychoactive thing. But THCA is weed. But there's all this THCA flower. So they had that. And that's illegal under New York law. Like, whether or not there's a federal argument for it, New York defines cannabis as total THC, which is 0.877 times THCA plus delta 9. So like they put it into the definition. So these investigators come in, they do like a literal SWAT style raid, and they seize some products, so on and so forth. They did this to a couple of these shops, New York City. So the court analysis, searches were done without a warrant. But OCM claims that it fell under the administrative search exception. The exception applies to regulated businesses. The court said, yeah, sure, these are highly regulated businesses. That makes sense. But the legislature did not allow municipalities to adopt local laws for administrative searches, but limited the search power to businesses not in the directly of licensed businesses. So the sheriff's argument was that this list was for adult use businesses and did not include hemp businesses. The court was not persuaded by this, as the law does not distinguish in regard to license. So they said license, technically if you're a hemp retailer, you get a license. Essentially, the court found they needed a warrant to go in and do the type of inspection they were doing, and they just did not comply. They went beyond, OCM went beyond what they were able to do, and the legislature could not give the authority to violate the Constitution. And one of the things the courts focused in on was the courts, and this is all back here, the courts focused on local law. So the legislature said, under a local law, when we give you inspection powers, you have to do all of these things right here. These are in the law. But they didn't say that about OCM. And so the court really kind of focused on that and said, well, they gave local municipalities boundaries, but they didn't give OCM those same boundaries. And the court really had a problem with that and found that there was a likelihood of success on the merits that there was a Fourth Amendment violation. All right, we got like 1 minute. Are there any other questions? Anything at all? No?
I think a great final point to sort of wrap up on is one that was made earlier, which is this is a new regulatory regime that is not without faults. The regulations that have been adopted appear to be somewhat of a living regulation, such that I anticipate as some of these issues come to the forefront, we'll see changes in legislation or regulation to address some of the issues that we identified. And it will only take the right action and the right judge and the right decision to help us to define what some of the municipal regulatory powers are as it relates to this sort of state regulatory regime. And it's been really fun and interesting for guys like Jason and myself to kick around in an academic way the bounds of the municipal authority in this space, and it will be fun for all of us to watch as the regulations and the legislation continue to unfold. So we're sort of in this together, and maybe we'll have an opportunity to come back at a future lecture and decide whether we were right or wrong or where things came down. But thanks so much for giving us the time.
All right, let's keep it going for Jason and Corey. Thank you again for joining us. Okay. I have the pleasure of inviting all of you to lunch catered by Jackson Soul Catering, which is on the second floor of this building in the gymnasium. The elevator is out that way. That would be your left, my right. If you're here for CLE, please be sure to turn in your CLE form to my colleague, Lisa Rivage, at the CLE desk where you walked in. If you're not getting CLE, you don't have to worry about that. But thank you again. And for those of you who are online, we'll be back here at 2:15 and in here in person, 2:15. The next phase of the program, the Government Law Review Symposium, will start at 2:30. Thank you.
Thank you. Yeah, it's great.